The International Criminal Court is now in session.
Sorry, Madam President, I think you're on mute, unfortunately. Thank you, sorry.
Thank you so much. Yeah, I forgot that I have to initiate that. So I'll start over. Thank you very much. So good morning, everyone. We're going to hear the pleading in the prosecutor versus Lord Blaze, the round of the last 16. Welcome. My name is Ines Peterson. I'll be the presiding judge this morning. And with me, I have my learned colleagues, Marie O'Leary and Owiso Owiso. We're looking forward to the pleadings of both teams. If you could quickly introduce yourself at this point. For the prosecution first, please.
May it please the court, my name is Van Rattingen, and I represent, as you know, the Office of the Prosecution. I'll be speaking for the full 25 minutes, and I reserve 5 minutes for our rebuttal. May it please the court.
Thank you very much.
Madam President, Your Honours, may it please the court. My name is Elias Kong, and alongside my co-counsel, Ms. Hannah Tan, we appear on behalf of the defense. I will address this court first for 13 minutes on the first 2 issues. Ms. Tan will then address this court on the remaining 2 issues on interest of justice and Lord Blaze's individual criminal responsibility.
Thank you very much, counsel. So as you know, you have in total 25 minutes to present your arguments. It is now time for the prosecution first.
May it please the court. Madam President, Your Honours, the present matter is of considerable concern to both the Earthbow people of the Earth Nation and the broader international community. The alleged enslavement of at least 30,000 Earthbowers cannot go without international scrutiny. And specifically, Lord Blaze himself must be tried for his conduct before this court, such that his criminal responsibility can be judicially determined, and his victims may therefore obtain justice. In response to the defense's challenge on jurisdiction and admissibility, we make 4 submissions. First, that this matter falls within the jurisdiction of this court. Second, that this matter is admissible before this court. Third, that this prosecution serves the interests of justice. And finally, there are reasonable grounds to believe that Lord Blaze himself is criminally responsible for the crime against humanity of enslavement. Your Honours, for those reasons, we urge this court to progress this matter to the confirmation of charges stage. I turn now to our first submission on the jurisdiction of this court. Your Honours, the resolution of this jurisdiction issue turns on whether jurisdiction ratione materiae can be established on the facts. As the prosecution, we bear the onus of proof on the balance of probabilities in accordance with this court's decision in the 2010 decision of Bemba Gombo at paragraph 203. Accordingly, we submit that both the contextual elements and the material elements of the crime against humanity of enslavement have been established. Therefore, our first submission has 2 limbs. I turn now to our first limb of this submission, the contextual elements of the crime, which characterize this with international seriousness. Pursuant to the chapeau of Article 7.1 of the Rome Statute and Article 7.2a of the Rome Statute, the conduct has satisfied the contextual elements of a crime against humanity, pursuant to the statements of this court in cases such as the 2011 judgment of the situation in the Republic of Cote d'Ivoire at paragraph 29, and more recently the case of Burundi heard at 2017 at paragraph 32. We thereby submit that the following 5 elements can be established. First, that there was an attack directed against a civilian population. Second, that this attack occurred pursuant to a state or organizational policy. Third, that this attack was widespread or systematic. Fourth, there was a nexus between the individual acts and the attack. And finally, there was knowledge of this attack. We submit that the Earthbowers, a civilian population, were the primary target of attacks occurring since 2015. Specifically, they were targeted during the government crackdown that occurred in 2015, with their ceremonies and rituals forbidden at paragraph 4 of the case facts, their language prohibited in schools also at paragraph 4, and their houses frequently searched at paragraph 5. They were also targeted for the educational centres, as stated by Azila at paragraph 9 of the case facts, and they were the sole party that was detained at paragraph 10 in the mass 2018 detention. We submit that the anti-extremism order, coupled with the 2015 government crackdown, both serve as the state policy which enabled these attacks against the Earthbound people. Further, we submit on the third element that these attacks were widespread as they were massive, frequent, and carried out collectively against a multiplicity of victims, with at least 30,000 Earthbounders being enslaved in one detention center alone. We compared this to the case of Bemba Gombo, for example, where the court found that 1,000 victims was sufficient to meet this standard. On the fourth element, we submit that the acts were not isolated here, that the detention, for example, was related to the enslavement. The 2015 government crackdown was a campaign against the Earthbound people that culminated in this enslavement. And finally, on knowledge, Your Honours, we submit that the perpetrators here had the requisite knowledge, pursuant to the case of Sanovic, heard by the Appeals Chamber in 2014. We note that Lord Blaze's specific knowledge will be addressed in my fourth and final submission, where here the intermediary perpetrator's knowledge is sufficient for the jurisdiction issue. For those reasons, Your Honours, we submit that the contextual elements can be established. I turn now, therefore, to our second limb of our first submission, being the material elements of the crime against humanity of enslavement. These material elements establish whether this specific crime can be established, and we apply the elements of crimes, Article 7(1)(c). The key issue here is whether there has been an exercise of ownership rights over the Earthbound people that were detained in Centre Rig. I draw an analogy to the cases heard by the International Criminal Tribunal of the former Yugoslavia, such as Kunarak and Knoyalak, as these touched upon enslavement. And specifically in Kunarak, the court held at paragraphs 119 to 121 that ownership can be demonstrated through a treatment of people as property. I thereby point to the following 4 factors as demonstration of enslavement. First, the Earthbound's labour being loaned to Joe Snowflake's company, with the aerial footage at paragraph 14 demonstrating this. I do anticipate that the defence will argue that Snowflake has himself contended the validity of this evidence, given his statements at paragraph 15. However, we submit that in light of this aerial footage, which has been obtained without any suggestion of forgery, as well as Harry Rock's testimony, although again he was a detainee, can be taken into account given that Joe Snowflake is a person with a direct interest in rebutting the attack on him as having engaged in serious human rights violations. And therefore applying the International Court of Justice's standard in the case of the Bosnian genocide case in 2007, parties who do have a direct interest, their evidence should be taken on with consideration of this weight. And therefore we rely on Harry Rock and this aerial footage as demonstrative of this forced labour. On the second point, I note that there was forced labour, and this is indicated by the fact that the Earthbounders had no consent in whether they would participate or not. We draw an analogy to the case of Knoyalak, where there the punishment was solitary confinement for not working on, similarly, automobiles. Here the punishment at paragraph 12 of the case facts was for the Earthbounders to stand in the snow all day without food nor water, under constant surveillance, in front of a picture of Lord Blaze. We submit that this is sufficient to demonstrate that their labour was forced. And further on this forced labour, we point this court to the UN's 2015 resolution of the standard minimum rules of the treatment of prisoners, where rule number 102 states that prisoners should have at least one rest day if they are working. And we again state on the facts that they were forced to work every day, so the standard was not met. On the third point, we submit that there were severe measures taken to deter the prisoners from escaping, evidenced by Harry Rocks being the only survivor of his 2019 escape, and further with the aerial footage demonstrating a heavily guarded fortress. And finally, Your Honours, we submit that Azila and the BNS treated the prisoners as though they were owned, as they restrained their freedom of movement and individuality through the further persecution of their language and culture, as they were forced to work, as well as the fact that their passports were not released even upon their release from the centre rig. On that basis, Your Honours.
Councillor, I have one question. I can follow your arguments, and the question that occurs to me is the prosecution submitting that all the people detained were civilians, or how would you, for example, deal with, I gather from the fact that some of them, let's say, may have qualified, let's say, as terrorists. Is that an issue for the prosecution or not?
No, Madam President, it is not an issue on our submission, as there is sufficient, even if there is the allegation that Aang members were quote unquote terrorists and therefore detained, we submit that there is no indication that all 30,000 of the Earthbowers were indeed Aang aligned, for example. And specifically, we point this court to paragraph 6 of the case facts, where it is noted that 54 of the Aang loyalists did flee after the 1,450 Earthbowers were killed. And finally, to conclude my answer to your question, pursuant to the case in Côte d'Ivoire, a civilian population excludes that of those who are armed forces. And again, there is no indication that the Earthbowers were hostile or were armed. On that basis, Your Honours, we submit that the ratione materiae requirement for jurisdiction has been established, and thereby I turn to our second submission, which is on the material element, which is, I withdraw that, on the admissibility of this matter. In response to the defence's unfounded challenge to the admissibility of the present matter, we submit that the defense has not dispensed with their burden as the challenging party to prove that this matter is inadmissible. Simply put, our second submission is as thus: there was no trial of Lord Blaze in domestic proceedings. A submission here has 3 parts. First, that the amnesty should not be recognised under international criminal law principles. Second, alternatively, that Lord Blaze was not tried pursuant to Article 17(1)(c) of the Rome Statute, upon which the defence relies. And thirdly, again in the alternative, there has not been any assessment of the conduct central to this complaint, being the enslavement. On the first limb, Your Honours, we submit that the defence cannot rely on law number 14 on national reconciliation, as it is inconsistent with international criminal law principles. Specifically, we refer this court to the European Court of Human Rights decision in the case of Margus in Croatia, where there at paragraph 130 and 139, the court found that customary international human rights law was incongruent with accepting amnesties to shield one from their serious human rights violation. We bolster this
Council, Madam President, may I ask a question, please? Council, can you please give us, is there a definition in that ECHR case or somewhere that you're relying on for what we mean by amnesty? Because the Rome Statute does not contain one that we can use.
No, Your Honour, I do not have a definition that was relied upon by that court for an amnesty, but the definition of what an amnesty is not, our submission does not depend on this, as specifically in that case, the court found that blanket amnesties or such that would not provide for the reparations or compensations to victims were not compatible, as it would effectively obliterate the rights of victims in the face of serious human rights violations. And it is upon that we rely, and we support this with the case of Gaddafi and al-Sanusi heard by this court in 2013, whereby the court said that the Rome Statute operates to prevent impunity, and we submit that this is such a case. On the second limb, however, should the amnesty be accepted, we submit that pursuant to Article 17(1)(c), Lord Blaze has not met this threshold, as he has not been tried. Article 17 of the Rome Statute respects the principle of complementarity between the state parties, the operation of this court, and the Rome Statute. However, such respect cannot be weaponized by the defense to preclude him from being tried by this court. Specifically, Article 17.1 states that a matter will be inadmissible where, I quote, the person concerned has already been tried for conduct which is the subject of the complaint. Pursuant to this court's decision last year in the case of Gaddafi at paragraph 48, Lord Blaze therefore must have been the subject of a completed trial which resulted in a final conviction or acquittal and acquired a res judicata effect. It is our submission that there has been no such proceeding which has acquired a res judicata effect, and therefore this is not an inadmissible case before this court. Specifically, we point this court to Article 3, articulated at paragraph 20 of the case facts of the amnesty law, which was performative, as it did not engage in assessing the merits of Lord Blaze's criminal responsibility, and neither did the apology confirmed by the judge demonstrate or engage in an exercise of judicial function of assessment of such criminal responsibility. And on that basis, there is no trial. Alternatively, again, Your Honours, our third limb is that even if there has been a trial, there has not been any assessment of the conduct that is present in this complaint. Specifically, Article 1 of the amnesty law was to excuse the hostilities that occurred in Black Mound, which is territory outside of the Fire Republic, whereas Centre Rig occurred in the Fire Republic. Therefore, this amnesty does not apply for Lord Blaze's conduct regarding the enslavement in Centre Rig.
Councillor, if I may interrupt, just clarify something for me here. Are you asking us to assess the correctness of the decision made by the domestic court in respect to the amnesty law, applicable to Lord Blaze? And if you're asking, if that's indeed what you're asking us to do we actually, as a chamber, as a pre-trial chamber, have the authority to assess the correctness of a judicial decision from the Republic, from a domestic judicial decision? Do we have that authority?
Not necessarily with respect to determining whether this amnesty is operant or not. That is not the question we are asking this court to answer, as this is merely an alternative. Rather, we submit, as in the case of the situation in the Islamic Republic of Afghanistan, the court didn't need to make an assessment as to whether the amnesty law was correctly engaged or not, but found there that the existence of such an amnesty law was sufficient to demonstrate that there had not been any domestic proceeding as the function of this amnesty here. We do acknowledge the need to respect comity, and therefore this is merely an alternative submission that we make, Your Honour. That does conclude our second submission, and I now turn to our third submission, which is regarding the interests of justice. We submit as a threshold issue, however, that this chamber respectfully does not have the requisite authority to assess the decision of the Office of the Prosecution to pursue this matter on the consideration of the interests of justice. And we apply the reasoning of this court in last year's case, in the case of situation in the Islamic Republic of Afghanistan. There, the appeals chamber expressly overturned the pretrial chamber's decision to review a decision by the prosecution to proceed on the interests of justice consideration. Rather, the correct approach is to look at Article 53 of the Rome Statute, which is the relevant reference to the interests of justice, and there only a negative duty is conferred on the prosecution to not proceed where it is not in the interests of justice to do so. Here we submit that this is the converse situation, as at this stage the prosecution has decided to proceed with the prosecution, and therefore it is not reviewable by this court on the interests of justice grounds. Nevertheless, Your Honours, seeing as the defence has made submissions on this, we submit that even if this is a reviewable ground, that the current prosecution does indeed serve the interests of justice for the following three reasons. First, this prosecution of Lord Blaze has not impacted the peace processes between the conflicting parties, namely the Ang and the Fire Republic. This agreement was signed in April 2019 at paragraph 7 on the basis that the Ang and the Fire Republic would engage in a ceasefire, not on the basis that the Fire Republic had been enslaving earthbowers and that they would thereby be released. The revelation of the enslavement of the earthbows occurred post the signing of this peace agreement, and this is found at paragraph 21 of the case facts. Second, we submit that this crime against humanity of enslavement is a serious crime which weighs heavily in favor of pursuing this matter. The gravity of this crime is illustrated by the fact that there were 30,000 earthbowers enslaved, and the fact that these victims were identified and discriminated against, and they were a minority to begin with in the Fire Republic. And third, Your Honours, we submit that the victims here can be inferred to have been interested in pursuing this matter, given that their nation, being the Earth Nation, has explicitly referred this matter to this court at paragraph 24 of the case facts. On that basis, we submit that this prosecution does indeed serve the interests of justice. That takes me to my final submission, Your Honours, where we submit that there are reasonable grounds to believe that Lord Blaze himself is criminally responsible for the crime against humanity of enslavement pursuant to Article 28B of the Rome Statute. The crux of this submission turns on whether there are reasonable grounds to believe that Lord Blaze had the requisite knowledge, control, and ability to take all necessary and reasonable steps to prevent this crime against humanity of enslavement. We emphasize that this is still at a pretrial stage, and therefore the relevant standard to be applied by this court is whether there are reasonable grounds to believe in his criminal responsibility, applying the standard at Article 58(2)(d) of the Rome Statute. Our submission here has three limbs once more. First, that Lord Blaze had a superior subordinate relationship between Azila and the BNS and himself. Second, that he had the requisite mens rea as to the crimes being committed. And finally, he failed to take any steps to prevent or repress the commission of this crime. On the first limb, we submit that Lord Blaze both had the de jure and de facto authority over Azila and the BNS to prevent this crime. We apply the statements of the International Criminal Tribunal of the former Yugoslavia in the case of Karadzic, as well as the case of Music, where there the courts found that these two standards were sufficient. On the de jure point, we submit that Lord Blaze as president had de jure authority over the BNS and Azila, and this engages in a presumption of authority. Nonetheless, we anticipate that the defense will attempt to rebut this presumption on the facts, but we submit that the facts also confer a de facto authority on Lord Blaze. Specifically,
I have one little question. You just referred us to the ICTY cases, Karadzic and Music. Isn't there any ICC jurisprudence on that point?
Yes, Madam President. I refer the court now to the 2016 decision of Bemba Gombo, which I know does apply the Yugoslavian tribunal's decisions, but specifically at paragraph 188 of the 2016 decision, we rely on the similar indicia perceived by this court to be important. Specifically, that Lord Blaze was empowered to issue orders relating to the movement and location of his detainees, as well as being able to authorize requests for supplies. We draw this court's attention to Exhibit 1, his conversation with Ursula Zila at lines 6 to 9 to demonstrate this. Second, Lord Blaze demonstrated his subordinates' compliance, or rather their compliance was demonstrated through clarification 2, where Azila did comply with his reporting mandates. And through Exhibit 1, it demonstrates that she even reported to him outside of these reporting mandates. And finally, Lord Blaze had the direct power to directly release the detainees. And this again is clear at Exhibit 1, lines 7 to 8, where he ordered the release of some detainees.
Council, I have one more question. Since you're basically establishing that Lord Blaze failed to prevent the crimes, can you point us to specific evidence that shows that he was aware of the crimes at the time or before they were actually committed? Thank you.
Certainly, Madam President. That takes me to the second limb of our final submission, being his requisite knowledge. Here we submit that he had actual knowledge of the crimes pursuant to Article 28B1. And applying Bemba Gombo once more, we submit that circumstantial evidence can be used to demonstrate his knowledge of the crimes at hand. And we rely on the following two factors to demonstrate this. First, there was an effective reporting system in place between Azila and Lord Blaze, which, in accordance with Bembagombo at paragraph 431, demonstrates a priori knowledge as he was part of a reporting system. But further, Exhibit 1 again demonstrates that he had continuous contact with Azila outside of this reporting period. Second, we submit that Lord Blaze was aware of the nature and scope of the conduct at hand. Specifically, I draw this court's attention to Exhibit 1, where he was aware of more men and supply being needed for the camps. He knew that they were, quote, working on something, being the detainees working on something. And finally, he was concerned with a mutiny. This, we submit, is inconsistent with the belief that there was a well-settled educational program set up by Azila, as she publicly stated. On that basis, with this circumstantial evidence, we submit that Lord Blaze did have actual knowledge of the crimes that were occurring. And finally, on my last limb, we submit that Lord Blaze, with this knowledge and with this ability, failed to take all reasonable and necessary steps to prevent this crime. He had the material responsibility here to prevent Azila and the BNS from conducting the crime, to report the crime to the relevant authorities, and he did not do so. It is also noted that he had the ability to stop them from committing crimes, as at paragraph 17 of the case facts, he was able to order them to engage in a peace agreement with the Ang troops. On that basis, Your Honours, we submit that there are reasonable grounds to believe that Lord Blaze is criminally responsible for this crime. Madam President, I note my time's expired. May I conclude my submissions? Thank you.
Very quickly.
In light of those submissions, Your Honours, we submit that the case facts here demonstrate on the balance of probabilities that Lord Blaze, that this matter does fall within the jurisdiction and is admissible before this court. That concludes our submissions. May it please the court.
Thank you very much, counsel. And now for the defense, please.
Madam President, Your Honours, may it please the court. Your Honours, this court's mandate stems from the consent of state parties, and parties have only consented to try the most serious crimes of international concern. Now, unless there are facts making out such an egregious crime, this court has no jurisdiction. Now, even if such a serious crime did exist, this court must still respect the sovereignty of individual states by giving effect to the principle of complementarity. And in light of this, I have two submissions to make today. First, that this court does not have the subject matter jurisdiction to hear this case because the material element of enslavement has not been made out. Second, that this case is inadmissible pursuant to Article 17(1)(c) because Lord Blaze has already been validly tried before a Fire Republic judge. With that, I begin with my first submission relating to the subject matter jurisdiction of this court. Now, on this point, the prosecution has relied principally on 4 factors to establish the most serious crime of enslavement. They are 1, the forced labor of the detainees; 2, the inhumane working conditions within Centuric; 3, the prevention of escape of the detainees; and finally, the treating of detainees as objects. Now, with respect, these 4 factors, whether individually or taken together, fails to demonstrate reasonable grounds for believing that the crime against humanity of enslavement has taken place. Now, first, the prosecution's reliance on the standalone factor of forced labor is incorrect as a matter of law. Involuntary forced labor in and of itself does not amount to enslavement. In the context of detention centers, compulsory labor is often employed as a means of corrective punishment. Indeed, detainees can be made to work under reasonable working conditions, and this was held by the ICTY trial chamber in its 2002 decision of Chrono Yelach. And therefore, the true question here is not whether there was forced labor or not, but whether the working conditions within center rape was so egregious that it demonstrated an exercise of ownership powers. And this is, in essence, a separate factor the prosecution relies on. Now, on this factor, the prosecution argues that the detainees were abused and mistreated, and this amounted to such harsh working conditions which made out the crime of enslavement. Unfortunately, this argument suffers from a simple yet crucial logical gap. It is not enough for the working conditions to have been bad. They must have been so bad that it evinces an exercise of any or all of the powers of ownership attaching to the right of ownership, my apologies. Now, this is the defining characteristic of enslavement, clear from the express wording of Article 7.2c. Now, to identify this defining characteristic, there must be facts pointing to the victim being reduced to a commodity such that the person is an object of enjoyment of possession. This was held by the ECCC Appeals Chamber in its 2012 decision of Kaing, and also conceded by the prosecution in its fourth factor. Now, most cases do not demonstrate such a level of commodification, especially so in the context of detention centers. And in cases which did, the facts there were particularly egregious. Now, unlike the cases the prosecution relies on, specifically Kunarat and Chrono Yelach, which relates to sexual enslavement, we have a case here which relates more directly to detention centers and enslavement in the context of detention centers, and that is the case of Kaing itself. Now, in the case of Kaing, detainees, both adults and children alike, were used as farm animals for plowing fields. And when they fell from exhaustion, they were beaten and threatened to keep going or risk disappearing. As a result of this inhumane cruelty, a majority of the children died from hunger and sickness. Now, while they were worked to death during the day, at night they were shackled like animals, literally treated as commodities and objects of use. Now, the facts of the present case are far removed from such commodification. If we turn to the description of center rape itself, we see that the detainees were worked 12 hours a day, and in the face of defiance, they were punished by standing outside in the snow. Now, we acknowledge that these may not have been the most ideal of conditions to work in, but this, contrary to what the prosecution claims, does not mean that there was an exercise of ownership powers over the detainees. It does not mean that they have been reduced to a mere commodity and utilized as objects of use. Ultimately, Your Honors, these allegations of harsh treatment stemming from a single witness account does not demonstrate the level of commodification required to establish the crime against humanity of enslavement on reasonable grounds. Now, the last factor the prosecution relies on is the prevention of escape of the detainees. Your Honors, with respect, for a detention facility to effectively detain such dangerous terrorists, armed supervision and the confiscation of passports is completely understandable. It is in fact the norm rather than the exception, and should not be viewed as an extraordinary circumstance which demonstrates a level of control sufficient to establish enslavement. Now, that is not the only problem with the prosecution's argument, as this case is in any event inadmissible pursuant to Article 17.1c.
I have one question. As I just heard from you, is the defense admitting that all the detainees in the detention centers were terrorists, or may there have been some civilians as well detained? Could you elaborate on that quickly?
Madam President, we accept that the detainees may have been civilians. However, that has, whether they were treated as objects and enslaved is a separate question and a completely separate element which the defense is contending today.
Thank you, Counsel.
Now, the issue on jurisdiction is not the only problem with the prosecution's submissions, as this case is in any event inadmissible pursuant to Article 17.1c. Now, as a preliminary point, Madam President earlier queried the prosecution on the definition of an amnesty. And this is an important question because it determines if an amnesty can fall within a trial provided for within Article 17(1)(c). In this regard, we do have a definition from the International Committee of Red Cross 2017 Advisory Service on International Humanitarian Law. Now, that advisory service provides that an amnesty is an official legislative or executive act where criminal investigation or prosecution is prospectively or retroactively barred. And we say that such an amnesty does fall within the definition of a trial under Article 17(1)(c). So the crux of the debate here is on what the definition of a trial is and whether it is broad enough to encompass an amnesty as I have just defined. And in this regard, the prosecution argues for a narrow definition of a trial, which must require a full trial resulting in either conviction or acquittal and having acquired res judicata effect. Now, this narrow definition put forth by the prosecution cannot possibly uphold the object and purpose of the Rome Statute, which enshrines the principle of complementarity. In this regard, Article 31(1) of the Vienna Convention on the Law of Treaties state that a treaty shall be interpreted in light of its object and purpose. Now, one of the core objects of the Rome Statute is to uphold the principle of complementarity in order to respect the sovereignty of its state parties. And therefore, to uphold this principle of complementarity, an accused should be deemed to have been tried not only when the court renders a judgment on the specific merits of a case resulting in either a conviction or acquittal, but also when a court makes other final criminal decisions relating to criminal proceedings. The critical touchstone is an exercise of criminal jurisdiction, and there is no principled reason why that must require a full trial which either results in a conviction or acquittal. Now, on the facts, the amnesty, as I have just defined, clearly amounts to an exercise of criminal jurisdiction, which had acquired a res judicata effect. And if that is the case, then it must invoke Article 17(1)(c) of the Rome Statute. If the prosecution wishes to nonetheless proceed in this respect, they must bring the case within the exceptions captured under Article 23, which provides for situations of procedural impropriety or where the host nation has attempted to shield the accused. Now, on the facts, these safeguards are not even made out, and in fact, not even challenged by the prosecution. To therefore give effect to the principle of complementarity, this case should be rendered inadmissible. Now, the amnesty is not... Yes, Your Honor.
Before you proceed, I'm seeking clarity on a particular issue here. I appreciate the prosecution and the defense going back and forth on what constitutes a trial, but just a question. What exactly is the effect of the judicial decision, the domestic judicial decision? Is it that Lord Blaze cannot, under any circumstances, be held accountable for any alleged violation that he may have committed? Is that the effect of this particular judicial decision? Can he, just maybe to put it simply, can he ever be tried criminally for anything arising out of the conflict in Blackmount?
Your Honor, we say that the amnesty granted to Lord Blaze operated in the domestic sphere and not the international sphere. So in other words, the amnesty precludes domestic prosecution of Lord Blaze and does not directly intervene in the international sphere. So we are not saying...
Just a follow-up. So then, when granting the amnesty, when the domestic court was granting the amnesty, was the question of Lord Blaze's possible involvement in the crime against humanity of enslavement addressed?
Your Honor, we say that it was addressed in the judge's mind because the apology in that case was granted with respect to the crime of enslavement and the forced labor activities taking place within Center Red. And so the amnesty must have been targeted towards that apology, and that encompasses the crime of enslavement.
No, you guys proceed.
Now, the amnesty is not the only thing that both parties have agreed to. Indeed, the amnesty is merely one part of a larger restorative peace process, which makes it against the interest of justice to proceed with this case. And this ties in nicely to my co-counsel submissions, whom I will now yield the floor to, unless I may be of any further assistance. I conclude my submissions.
Madam President, Your Honours, may it please the Court. As earlier introduced, I am Hannah Tan, and I act on behalf of the accused, Lord Blaze. I will address Your Honours on the next two issues concerning the interests of justice and Lord Blaze's individual criminal responsibility. Your Honours, the current conflict has resulted in immense violence, brutality, and suffering. That both sides of the conflict have now come together to peacefully settle the matter is no small feat. Thus, while this court does seek to ensure that the most serious of crimes do not go unpunished, this must be balanced against considerations of domestic peace. To that end, I make two submissions. First, prosecuting Lord Blaze would not be in the interest of justice pursuant to Article 53. And second, even if the crime of enslavement is made out, Lord Blaze is not individually responsible pursuant to Article 28G. Turning to my first submission, the prosecution's case against Lord Blaze does not serve the interests of justice. The prosecution raises two arguments. First, that this court has no power to review whether a case is in the interest of justice. And second, that on the facts, it is in the interest of justice to proceed with the current prosecution. We disagree on both counts. First, this court has the power to review whether a case is in the interest of justice. The prosecution earlier relied on a 2020 case of Afghanistan to argue that where a prosecution has already decided to proceed with the case, then this court cannot review whether a case is in the interest of justice. However, this is likely an oversimplification of the law. And this is because jurisprudence on the issue of the interest of justice has not been entirely clear, with there being case law instead showing that the interest of justice is indeed reviewable. For example, in the 2017 case of Burundi, the pre-trial chamber held that although the prosecutor did not state that the investigation would not serve the interest of justice, the court nevertheless went on to determine that the case was in the interest of justice. And such a position was also mirrored in the 2016 case of Georgia by the three pre-trial chambers. And in light of these conflicting cases, we submit that our position that the interest of justice is reviewable is preferable. And this is because the very function of this court is to prevent frivolous, ungrounded, and predictably inconclusive investigations, which can only be achieved if this court is able to review the interests of justice. And indeed, this...
Counsel, I have one question. The prosecution, if I understand correctly, has relied on an appeals chamber decision in the Afghanistan situation for its argument. So are you suggesting that the pretrial chamber should depart from this jurisprudence, from this decision? And would we actually even be able to?
Yes, Your Honor. So pursuant to Article 21(2) of the Rome Statute, this court is not bound by the decision of the appeals chamber, and we urge this court to in fact depart from that decision, given that the case law in this case is not entirely clear on the issue. Now, having dealt with the prosecution's first point, I now turn to the second point, that prosecuting Lord Blaze would be in the interest of justice because of three reasons which they rely upon. First, the prosecution claims that the current prosecution will not destabilize the peace process. However, the defense disagrees. Here, both the Yang and the Far Republic have finally agreed to end the conflict and settle the matter peacefully. The carefully negotiated agreement saw the creation of both a truth commission and conditional amnesty, as stated at paragraph 17 of the facts. And importantly, this was not a mere one-sided agreement. Instead, both parties had ample opportunity to negotiate the terms of the agreement. In particular, it was agreed that Black Mount would remain semi-autonomous, and this is the very thing which the Ang wanted since the beginning in their fight for self-determination. Further, the Truth Commission was commenced only at the request of the Ang itself, again found at paragraph 17. And in fact, this commission comprised of both earthbowers and representatives of the Far Republic, as stated in clarification number 5. And all these reflect that the parties had sincerely desired to settle the matter peacefully. All they wished is to regain a semblance of normality in their lives, and to forgive and to forget. Should this court now choose to proceed with Lord Blaze's prosecution, disregarding what both parties have agreed, the painstakingly negotiated agreement would break down, and the instability which ensues will cause yet another period of violence to erupt. As such, proceeding with Lord Blaze's prosecution would destabilize the current peace process, which would not serve the interests of justice. And in fact, the prosecution had also pointed out that it is the Earth Nation who referred the current situation to this court. However, all this shows is that it is a third party who desires for Lord Blaze to be prosecuted, and not the parties themselves. Now with that, I turn to my second and final submission, that even if—
Before you proceed, has this court ever been faced with a situation similar to what you're describing, where it had to strike a balance between a possible prosecution and an ongoing peace process in a situation country?
Yes, Your Honor, there is just one case which has came before this court, which would be the case of Uganda in the year 2001. However, in that situation, the court actually proceeded with the prosecution. And as a result of the arrest warrant issued against Mr. Joseph Kony, what occurred was that the conflict in Uganda actually resumed. And it was only in the year 2021 that Mr. Joseph Kony was finally convicted. And on that basis, we submit that it shows the extent which proceeding with Lord Blaze's prosecution could possibly bring to the nation. Now, turning to the second submission, the prosecution first argued that Lord Blaze possessed the relevant mens rea of knowledge. Preliminarily, we note that the mens rea of either actual knowledge or conscious disregard must be proven under Article 28B. And as the prosecution relies on the limb of knowledge, we shall meet their case where it is at. Now, in this regard, the prosecution relied on two main factors. First, the fact that there was an effective reporting system as evidenced by Exhibit 1, which shows continuous communication between them. However, Your Honours, even more important than the presence of such a system is the exact contents of the report and the communications. And in this regard, what Exhibits 1 and 2 show are mere routine exchanges between Lord Blaze and Minister Azila. There is no information showing that Lord Blaze was informed about the treatment of the detainees such that he would have known that they were actually being enslaved. And even placing the contents of these reports aside, the frequency of communication between Lord Blaze and Minister Azila also shows little basis to infer that Lord Blaze knew of the enslavement. Now, going back to the case of Bemba, which is the very case which the prosecution earlier relied on, there, the accused and his subordinates discussed their operations daily and as frequently as 4 to 5 times a day. And in fact, in the span of just 1 month, there were 129 calls being made between the accused and his subordinates. Now, this stands in stark contrast to our case, where an official report is only required every 6 months. His phone calls with Minister Azila were also short and of a general nature. There is thus little basis for inferring based on the irregular and isolated insurrections that there are reasonable grounds to believe the Lobleys knew of the enslavement. Now, the prosecution also directed Your Honours to the fact that Lobleys feared a mutiny. However, we submit that all this shows is that Lobleys, as President of our Republic, was concerned for the national security of his country. And this is because the education centres housed numerous young leaders and loyalists who were rebels. They had incited violence within Fire Kingdom on more than one occasion and therefore posed a threat to national security. Even if they had vowed to amend their criminal past, it was fully reasonable for Lobleys to still be wary of their actions and take precautionary measures against a revolt. Thus, he was completely justified in worrying about a mutiny, and this does not show that he knew of the enslavement. I turn now to the final limb, which the prosecution earlier relied on.
Madam President, may I ask a question and intervene, counsel, quickly? You're talking about two very brief conversations. Does Lord Blaze not have more of a responsibility since he made the order that by any means this matter should be taken care of by the minister? What we may be seeing here is something of a conscious disregard if we're looking at the status of mens rea. Is it possible that he bears some omission liability for not following up and getting true facts on this?
Your Honour, I see that you are perhaps concerned about the duty of a superior to remain informed. And indeed, this is a matter which has been discussed in the international jurisprudence. And in this regard, what the courts have held is that while there are general obligations imposed on superiors over their subordinates, a superior's mere negligence in remaining informed is insufficient to result in liability. And instead, liability only arises if a superior failed to act despite already knowing of the crime. And this was held in the ICTY case of Celebici at paragraph 226, and also emphasized in the 2018 case of Bamba. Now, turning to the duty to prevent. As Madam President had earlier queried the prosecution, the duty to prevent only arises if the prosecution proves that Lobleys even knew that the crimes of enslavement were being committed. However, as previously submitted, Lobleys does not even know that the crimes were being committed in this case, and as such, the duty to prevent the crime never arose. Now, Your Honours, I note that my time is up, and unless I may be of further assistance,
Thank you.
This concludes my submissions.
Thank you very much, counsel. And we will now turn for the rebuttals. The prosecution first, please.
May it please the court. We have 5 points in rebuttal. First, on the material elements of the crime against humanity of enslavement, the defence submitted that the forced labour was insufficient to demonstrate the exercise of ownership rights, and rather the question is of the treatment of the detainees. This is an error of law. In contravention of established international norms such as the UN Convention on the International Minimum Standards, as I referred to earlier in my submissions, that in some circumstances, as well as footnote 11 of the Elements of Crime, Article 7(1)(c), in some circumstances, a deprivation of liberty may result in ownership, and this includes exacting forced labour. On the factual side, we have pointed to the forced labour, specifically being labour that does fall under ship ownership, as it did fall within the definition of bartering or lending of labour, as the labour was loaned to Snowflake, evidenced at the aerial footage at paragraph 14. And finally, we rely on the case relied upon by the defence, Kine, that the earthbows were treated poorly, and rebut that further still. That the earthbows here were treated poorly, again, by the punishment that they were to face if they could not work based on either their unwillingness or inability to work. And on that basis, we submit that the earthbowers were indeed, on the balance of probabilities, subject to ownership rights. On Article 20, Subarticle 3, being our second rebuttal, the defence submitted that this ne bis in idem exception has not been engaged. and this is an error of fact. Lord Blaze explicitly himself at paragraph 23, quote, sought the amnesty to protect himself against any criminal prosecutions, and therefore Article 20, subarticle 3A has been engaged. Third, on the power to review the interests of justice, the defence has submitted that this power does exist with reference to the case of Burundi. However, this is an error of law. As specifically, the appeals chamber, as noted by Madam President, has held that there is no power to review the discretion of the prosecution. We rely broadly on the statement at paragraph 26 of Afghanistan, where they stated the starting point of the appeals chamber analysis is articles 15 and 53, and therefore there is a delicate balance that must be struck between the discretion of the prosecution and the power to review of this court. Here we submit that therefore this power only falls within the actual context of Article 53(3), which is when a prosecution has decided not to proceed. And fourth, on Ang's peace agreement, the defence has relied on this peace agreement between Ang and the Fire Republic as demonstration that the interests of victims did not serve the prosecution here. However, this is a misinterpretation of the facts. As first, the Ang are not representative of the Earthbow victims in spite of their aligned interests. There is nothing on the facts to demonstrate that they hold any more bearing as the Earth Nation, for instance. But second, the Ang, as I have submitted, agreed to the peace between the parties without any knowledge of the enslaved Earthbowers. And therefore, this specific peace agreement does not include any excuse of the alleged enslavement of 30,000 Earthbowers. And this is important as it demonstrates there are no sufficient reasons to preclude the vital function of the prosecution to prioritise justice. And finally, Your Honours, on the mens rea of Lord Blaze, the defence submitted that there was no information regarding the treatment of detainees and their enslavement, and whether Lord Blaze was aware of this. We submit that this is an error of fact, and again press forward with the fact that this is a pre-trial decision and the standard is that of reasonable grounds to believe. We submit here that a reasonable inference can be drawn, and we point to the actual content of Exhibit 1, that Lord Blaze was indeed aware of the enslavement. As the defence has pointed out, he was concerned of a mutiny, but this is not consistent with his belief or desire to keep his country safe. As Azila herself stated at paragraph 9 of the case facts, that the prisoners who engaged in a voluntary educational program were, quote, grateful for her help. This, Your Honours, is inconsistent with any belief that there was a well-settled voluntary educational program. And as pointed out by Judge O'Leary, Lord Blaze did have the duty to seek as to whether there was an enslavement occurring, and we rely on the Nuremberg trials decision in the case of Poe to demonstrate that such a duty did indeed rest with him. That concludes the submissions of the prosecution. May it please the court.
Thank you very much, counsel. For the defense, please.
Your Honours, 4 points in Sir rebuttal. First, regarding Article 23 and whether there was indeed shielding in this case. Now, in this point, the prosecution has argued that the amnesty amounted to an act of shielding Lord Blaze from criminal responsibility. Unfortunately, this argument has left out a crucial requirement under Article 23A. It is not enough for the domestic proceedings to have in fact shielded Lord Blaze. It must have been intended to shield Lord Blaze, and this requires proof of bad faith. This requirement of bad faith can only be shown by intentional omissions or serious deficiencies in the conduct of the proceedings. And on the facts here, the judge had conscientiously determined if the set of conditions were met before granting Lord Blaze an amnesty. Clarification number 6 to the facts further crystallizes this as it states that the amnesty was lawfully granted. And indeed, there is no evidence that the judge or Fire Republic for that matter has acted in bad faith. Now, secondly, pertaining to the interest of justice, the prosecution again relied on the 2020 case of Afghanistan to make her point. However, in this regard, we note that no new submission has been made, and we stand by our previous submissions. Now, third, pertaining to the peace agreement, the prosecution further argued that the Eng themselves were not actually the victims in this case. However, Your Honours, in the current situation, it was the Eng leaders and loyalists who were subject to the alleged enslavement, as stated at paragraph 8 of the facts. And in turn, by agreeing to the amnesty and even initiating the formation of a truth commission, this shows that what they desire is not prosecution, but peace. And hence, it would not be in their interest should this court now prosecute Lord Bliss against their express wishes. The prosecution also made the point that they did not actually know of the alleged enslavement. However, the defense admits that based on the facts here, this is a very big assumption to make. To begin, it is difficult to imagine that the Eng leaders, who are experienced leaders of the rebel forces, would be completely unaware of what was happening in the education centers. And even if they were not aware of the exact extent of matters occurring in the detention centers, they would have some knowledge of the situation prevailing in these camps. And given that the Eng operated on the ground, they would have been aware of the needs and interests of the victims during the peace negotiations. As such, they would have sought to protect the interests of the victims during the negotiations and chosen the medium most desired by them. And finally, pertaining to the fifth point which the prosecution made, pertaining to the mens rea of Lord Bliss, that he had actual knowledge. The prosecution earlier pointed out that the standard of proof is a low one. However, Your Honours, the requirement of knowledge states that not only must one know of the general situation prevailing at that point in time, instead, they must know that the specific acts being committed amounted to enslavement. This was emphasized in the case of Oric 2009 at paragraph 323. Now, Your Honours, the fifth and most basic principle of Nuremberg is that all individuals should be subject to a fair trial. And in this case, we submit that the prosecution has failed to demonstrate that there are indeed reasonable grounds to believe that Lord Bliss committed the crime. And given that the current conflict resulted in much suffering and violence, prosecuting Lord Bliss would only turn back the clock and dig up old grievances, just when a semblance of normality has been achieved through the peace process. As such, the defense humbly prays for this court to dismiss the present prosecution. Now, unless I may be of further assistance, this concludes the case for the defense.
Thank you very much, counsel. So this concludes the pleadings. We will retire to the deliberation room. So bear with us. We will be back in a short while. Thank you.
So I will now send the judges to the deliberation room and the teams to separate breakout rooms. The judges will be here soon.
So are we all back? I guess. All right. Well, thank you for waiting. As you can see, we took some time for deliberations. I'll quickly explain why that was. But first, of course, we want to announce who the winner is. For us, by a very narrow margin, it is the defense. Congratulations to both teams. Maybe I should have started with that one and explain a little bit. We've been in the deliberating room for quite a long time. And of course, the deliberations are such a secret, but I think I can say that what we did for a long time was basically being impressed about both presentations to a very high degree. So we spent a lot of time with that. And then the next thing we did was spend a lot of time also with regretting having to take a decision that means that one team isn't going to proceed. And again, that was because your presentations for both teams were highly elaborate. We enjoyed them very much. Basically, I think we can sum up, have no criticism about it. And so in that respect, you should be very proud. And in that respect, we were we feel, I think I can express that for the bench in total, we feel very grateful that we could be part of this. If my colleagues have some comments, now would be the time.
I can only reiterate what the presiding judge has said. I just want to thank you all for coming today and really wowing us with all of you with your wonderful performances and arguments and responsiveness and the really skilled answering of questions across the board. All we can say to everyone here, keep it up in future rounds and future years and future careers, because it was really nice to hear all of you. Thank you.
Well, I'll have to agree with my fellow judges. All I can say is it has been amazing. It has been wonderful, impressive. I immensely enjoyed listening to you. And as I keep saying, you know, as I said to previous teams, I do not think I would have done this during my time, which is not very long ago. I would have, of course, I mooted back then, but I wasn't as impressive, or rather my cohort weren't as impressive as the teams that we faced, particularly you yourself. So this is very impressive. I'm very impressed. I'm very happy that I got to listen to you. And yes, it has been a difficult decision, yes, but I have enjoyed the process, and I hope you have enjoyed it more than I have, because you've done it more than I have, you know, sitting here listening to you. And going forward, I would say don't disappear, because, you know, as Judge Giulieri was saying, sometimes you see impressive teams here during the moot sessions and competitions, and then going forward, you don't see them. You know, after this, they disappear. You wonder where they go. We don't get to see them in this international criminal justice world. So keep it here. No, I mean, don't keep it here at the mooting session, but keep it here in this international criminal law world, because you're so impressive that we wouldn't want this talent to go wasted. So stick in there. Keep doing what you do. Enjoy the moment. It's not necessarily about winning. It's about enjoying the moment and getting, you know, accumulating a lot of knowledge, which you already have. So just keep it there. Keep doing what you do, and all the best in everything else that you do. I hope everything else that you do going forward will still be within the international criminal justice world, and I hope to see all of you around.
Thank you so much for your time, and congrats to the other team.
Thank you, all the judges, and good job to the prosecution too.
Thank you very much. And again, maybe one last word, if I may be allowed. You know, both presentations excelled on such a high scale that I'm actually now very grateful that it's also being live streamed and other people can look at it, because they just shine by themselves. And yes, unfortunately, we had to pick a winner, but that doesn't mean that that the presentation as such for both teams were just really extraordinary. So thank you again.
Thank you very much. I will now, first of all, stop the